Thank you, Mr. Chairman. Mr. Attorney General. In response to the first question that was posed by Chairman Conyers, maybe I misunderstood your response, but it went something like this, that if an opinion was rendered that a individual pursuant to acted in a way pursuant to a legal opinion of the Attorney General that would insulate him or her from any criminal responsibility regarding his actions as an Assistant Attorney General or someone from the White House. Or maybe I'm confused, because it sounded like a brand new legal doctrine to me.
I think what I said was that we could not investigate or prosecute somebody for acting in reliance on, we being the Justice Department, could not investigate or prosecute somebody for acting in reliance on a Justice Department opinion. This is the question specifically concerning the disclosure that waterboarding. If that Justice Department opinion was inaccurate and in fact violated a section of the U.S. Criminal Code, that reliance is in effect a immunity from any culpability, any criminal culpability. It is a justified reliance that could not be the subject of a prosecution. Immunity connotes culpability.
This is brand new legal theory, at least in terms of my own legal scholarship. I mean, relying on an opinion that is inaccurate, that's mistaken. And I'm not looking to prosecute any individual in the Department of Justice or any of our government agencies, but one would only need to secure a Department of Justice opinion to be insulated from prosecution. Am I accurately portraying your position?
What I said was that the disclosure that waterboarding was part of the CIA interrogation program at the time that it was carried out, and that it was permitted by a Justice Department opinion, should bar an investigation of the people who relied justifiably on that opinion in conducting their activity.
But for the sake of argument, let's hypothetically concede that waterboarding is in contravention to an international obligation pursuant to the Convention Against Torture. And if an opinion was rendered that amounted to malpractice, that whoever employed that particular technique, simply by relying on that opinion, would or ought not to be investigated or would be legally barred from investigation and criminal responsibility. Is that what you're telling us?
If you're talking about a legal mistake, there is an inquiry with respect to not the OLC opinions I'm talking about, but other OLC opinions relating to surveillance that relates to whether people properly rendered opinions or didn't. But to rely on an opinion that some later Attorney General thinks is mistaken, yes, bars the person who so relied in good faith from being prosecuted.
I find that position a new legal doctrine, if you will. The law is the law. We can all have opinions in terms of our understanding and interpretation of the law. And if what you're saying, and if we can agree just for the sake of discussion purposes, that waterboarding violates not only American domestic law, but our international obligations under the Convention of Torture, if there are an opinion promulgated by the department it insulates those who actually perpetrated the act, even ordered the act to be conducted.
The laws you are talking about are phrased in general terms, as to which there is a great deal of dispute. Some people lined up on one side, others lined up on another. If it comes to pass that somebody at a later date finds that the opinion should have been different from what it was, the person who relied in good faith on what the person who arrives later says was an erroneous determination is protected. Because to do otherwise would be to say to everybody out there, you can't rely on any.
But is there legal precedent for that statement that you just made to this committee?
There is a practical consideration.
Okay. But there's not a legal precedent for it?
I can't sit here and cite you a case.
Okay. I yield back.